Good evening.
Sorry, so sorry about the delay.
Yeah, it's fine. How
So
are you?
I realized
I'm fine too.
a bit late that the link that I sent to you. Can
I can hear you, please.
Hello?
I can hear you. I can hear you.
Can you hear me?
Yes, yes,
Oh,
I can
okay,
hear
okay.
you.
So I realized that the link I sent to you, I was supposed it was supposed to be the link for you and I, since we are the two people speaking. But then I
Okay.
published it. So I don't know if people that are supposed to join are going to try to be joining through that link, which means I have to admit them and they have to show. So I don't know how that's going to work. So in case it comes up during the session, and also because it was minimal publicity, what I prefer to do for this kind of sessions is record, pre-record, and then publish so that people can watch at their own timing. So
Okay.
I don't know how many people are going to be joining us, but anyone can just stream it much later. So it will just be like you and I are talking. Is that
Yeah,
okay?
sure. Sure, that's fine. That's fine.
Okay, great. So I welcome you to
You're welcome.
guests. Yes, I've had five. It had Bolade first, then Mr. Arushebe, then I had Mr. Agbo, Chimezie. Session.
I,
Today we want to talk about adumbration, and I've brought a guest that is very seasoned. Apparently, yes, can you hear me?
yeah, I can hear you now. There was a break at a point,
Can you
but I
still
can
hear
hear you
me?
now. I can hear you. Yes, please.
Oh, okay, okay. Okay, so if I'm breaking at any point, please let me know so that our talking will not go to waste. Thank you for joining. Thank
Sure.
you, Favor. Thank you, Dynamism Designs, and the other people that are on the call. So I said that I brought our guest to talk to us about adumbration today. Adumbration is I don't know if I should say it's important because I always say that all my topics on the channel are important, but I don't know if adumbration is important because you find that in most cases these days judges are not really that interested. I know that exceptions for senior lawyers and
Yeah,
lawyers
sure.
that talk well, so they want to hear their voice. But apart from that, generally they just ask you
Yeah.
in particular. I've requested for this video. I think someone did last year, then someone did like last week. So I decided, wow, let's do it. And I made a call on Twitter, and our guest was very, very which English will I use now? I want to say that he gave us the privilege of coming on the channel. Yeah, that's what I want to say. So thank you so much. I can see that you're very popular. People are already giving you votes of confidence on Twitter. As a matter of fact, I posted it on WhatsApp and the magistrate saw your picture and was like, this person, they said, Omoni Banji Odolaye Aremu's personal person, that they
Yes.
would have to be on this call to come and see you speak. So apparently you are very popular. So I welcome you. I'm going to do a short introduction. I've asked for his bio, so I'm just going to read it and then we'll get right into it. What we want to do on this call is to talk about adumbration. So you tell us what adumbration is, and then he would actually demonstrate it to us, with some cases. We'll try to do two types of cases and then you adumbrate. So let me introduce our guest properly. Today we have with us Mr. David Ogundipe. He's my senior at the bar, so he's the founding and lead partner at Earnest Attorneys LP, a law firm in Nigeria. Where's the law firm? Abuja,
Abuja.
is it? Oh, okay, capital city
Yeah.
people. So he's a lawyer, an attorney with 10 years of experience practicing across various areas of law at top Nigerian firms. He has represented a wide range of clients in matters related to constitutional law, labor law, election petitions, criminal law, international law, commercial law, family law, human rights, and debt recovery. You can see that he's very seasoned and he's skilled at in-court and out-of-court advocacy. He's focused on protecting the interest of clients and achieving favorable settlements, and is passionate and knowledgeable about issues such as rule of law, human rights, elections, democracy, international affairs, and the judiciary. His expertise is wide and has been recognized by the Nigerian Bar Association and has been recognized by this channel, and that's why we have him here today. So
Thank you.
I'm going to cut to the chase because he has a very long bio, you know. It's not easy to have worked for 10 years. So is it even 10 years? Yeah, 10 years. So he's is the right man for the job. So today he's going to be sharing with us from his wealth of knowledge and experience. He's going to be sharing with us what adumbration really is. And if you are a counsel that is interested in adumbrating, you should just how to do it. So I welcome you, Mr. Ogundipe. Thank you so much for coming to Battle Pitola. So if anyone has questions from those that were able to that have joined us online, will join us as we go on. You can leave it in the comment section, and don't forget that always on the channel, you can always leave your comments at any time and we'll get to it as soon as possible, even if you're streaming the channel, the video after we have done this session. So I'm going to start by asking you to tell us what adumbration really is. Yes.
Thank you so much, Ola. And I consider it a great privilege to be on this program. I've tried to look at the things you've done in the past, and it's quite impressive. And like I always say, I wish we have more of highly productive content like this that can guide younger lawyers. So thank you so much. Thank you so much. Now, I take
You're welcome.
this very seriously, and that's why I'm wearing tie. You know, anything I take seriously, there must always be a tie involved. So to go straight to the point, I've made some notes on the side that I might need to make recourse to. The first thing is just like several other words that we use in the, should I say, legal sector, in the legal parlance. The word adumbrate is actually of Latin origin. Ad, ad, which means to, the dumbra, which umbra rather, which means shade. So adumbra is shade. So it became adumbrate, which people use as to shade. Now, to bring some sense into it for a sense of completeness, when you say to shade, people might interpret it to mean that, okay, how does shading uh, has anything to do with, speaking in court and all that? So the meaning in this context is actually to shade, like to sketch something, a sketch of
Okay.
something. We all know that when we talk about sketches, we are not talking about like 3D images or hyperrealistic images. We are talking about something that gives you a glimpse, an idea of something like a part of a whole. Let me use that expression. So uh, I would say adumbration means highlighting the key points in a matter, particularly those aspects
Okay.
that you feel
I like
um, yes, the central points, the key points in a matter, particularly the aspects
the
that
key
you
points in
feel
the matter. Okay.
yes, brings some strength to your own case. So, in other words, we can talk about adumbration in the court of room advocacy. I see it as a brief oral sketch. I mentioned earlier that it's like sketching. So, it's like a brief oral sketch. You are not going into the entire, gamut of what you've written, your written addresses and all that. That is why you have the written address. So, there's definitely no point for you to be in court again and stand up in a rehash saying that four issues for determination, my lord. Issue one is, issue two is, and I believe that for many lawyers, what they call adumbration is actually not adumbration. What they do in court is to like go back to what has been stated already. You try to board the court and all that. So I say that adumbration should be like the dress of a well sought after princess. It should be short so as to reveal our appealing legs, yet long enough to cover the subject matter. So There's a way you throw it that even the way you start, the judge is willing to listen more. You cited an example, and most of the time I witness it. One question: oh, Mr. XYZ, is it in your address? Yes, it is there. So why do you want to say it again? Sit down. If you say that it is not there, like a friend told me that the judge is always asking, is it there? People say yes, he tells them to sit. This time around, I'll go there. If he asks, is it there? I'll say no, so that the judge would allow me. So when he went there and the judge said, is it there? And he said no, the judge said, okay, so why do you want to spring a surprise? Sit down. So it's not an opportunity to spring a surprise. It's like identifying a strong pillar, one or more strong pillars in a case that you know that there are points you need to make on it so that it creates a lasting impression on the judge as he or she moves into the recess of his chamber to say that okay, there was a particular point this person made. Okay, it interests me. I need to look critically into this case. I need to look at it more as opposed to the general outlook that a judge might give a case that, oh, okay, it's a contract matter, offer acceptance and consideration. Adumbration is an opportunity to speak to the dynamics of your case and to demonstrate to the judge that indeed there's something peculiar about this case that the judge needs to pay special attention to so that the verdict would be in your favor. So, on the introductory aspect, I think I'll leave it at that.
Okay, I think that you've done justice to that. So adumbration is in your own words, you say is you trace the origin, ad, dumbra, and all of that. I hope
Yes.
that whoever is watching will get it. Someone is asking for the name of your law firm, your name, your LinkedIn name, a lot. So you're going to tell us that at the end of it, and I'm going to put it in the description box. So not to worry, the person asking, you would find all that because as a matter of fact, I like making a lot of noise about my guests so that anyone that wants to connect with them afterwards and continue the value exchange can just do that, especially because they
Thank
are
you.
doing it for free. So
Thank
thank
you.
you so much. You will get the
Thank
answers
you.
to your question. So let's continue now that we've laid a foundation. I would like to ask, I said initially that in my experience, what I've seen, not personally, because I actually have I adumbrated before? In most cases, because now you have said that what we think is adumbration is never adumbration. So let me
No.
not say that I've adumbrated, I've not adumbrated. When you do the demo for us, I will know whether I've adumbrated or not. But I know that in most instances, I simply just tell the court that, oh, my lord, this is our written address. We seek to adopt it as our argument in the matter, and we hope that we urge the court to decide in our favor and grant all our prayers and all of that, and I just sit down. So, but I've seen in some cases that the court would ask some lawyers what you're about to say. Is it in your written address? They'll say no. They'll say yes, and then the court will tell them to sit down so that other cases can go on. Some will insist. They will keep talking, and then the court will refer them to their written address that I can see that you have put that in section or page so in your written address. Are you saying
Yes.
anything new about it? If not, then sit down. And I've also seen in some instances that a counsel will then start talking about new evidence or new information, and then the court will remind them that you cannot, introduce new evidence at this point, and so
No,
we
you
should
cannot.
stick to what we have done in the trial. So in the
Yes.
light of that, I would want to ask for your own personal experience in adumbration. Like the times that you stood up in court to adumbrate, have you been allowed by the court? And before I ask the next question about introducing new evidence, let's talk about your own experience so far.
Yes. I think I adopt everything you said. It reflects the actual reality in practice. I've had my own fair share of sit down, and I've had my own fair share of okay, keep moving. And what is important is, like I said, adumbration is like an oral sketch. You know, a glimpse of your case. Like, let's say something about you say when we say trailer, a movie trailer. Now
Mm-hmm.
you try to pick the most compelling aspect. when you want to adumbrate, a point that is very central, something that is almost irresistible. If you are calling it oral sketch, so you are a judge, and what we've presented in your court was that, okay, this thing is a dog. But I stood up in court and I said, my lord, I want to adumbrate and you allow me. Then in my oral sketch, you started seeing the trunk of an elephant. It raises suspicion that, oh, no, 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 this is not adumbration. You are trying to deflect from what has been presented. And that speaks to your point on introduction of fresh evidence, because that's what you are doing. Or you are trying to change the case at the address stage, at the adumbration stage. So when we call something adumbration oral sketch, it is like a part, a glimpse of what you already put before the court, so that when you are speaking, the court is not lost. The trial has been about law of contracts, evidence has been led in that line. Then when you get to adumbration stage, you started talking about defamation. The judge will definitely tell you to sit down. Now, the courts are very, very busy. The courts are very, very busy. And that is why, because of their experience, they know that when many lawyers stand up to say that, oh, we want to adumbrate, some are going off the tangent and all that, and they don't want to do that. So what I do most of the time, the tricks that uh, that have worked for me, like I did it in my Lord's court, Justice Olotu, when caught that day, and she mentioned that there was going to be a meeting of judges that she needed to attend to, but as a demonstration of seriousness, she was in court so that open court we can take data and all that. A case was passed to me. It's a case on enforcement of fundamental human rights, and it had lingered for like 3 years before a friend passed it to me. So we went to court that day. Our case was number 17. They were calling cases, they were calling cases, they were calling cases, they were calling cases. When she went on recess, I walked outside. The client came to meet me and said, this judge will not hear us today. So please, if you can get the next, the shortest date, that would be fine. I said, okay, let's see what we are going to do. So when she came back and our case was called, I stood up. And when I announced my appearance, she already said, okay, what date? So I stood up. I said, I thank your lordship. And I think I can remember verbatim what I said that day. I started. I said, when your lordship sits in the open court like this, we know that what obtains in the open court is like a fraction and fragment of the effort you put into the administration of justice. We appreciate that. And the fact that your lordship has more pressing assignments is not lost on me. But my lord, my case is peculiar. So I turned back. I pointed at my client. I said, my lord, the man sitting back is my client. For 4 years, his fate has been left hanging in the hands of his employees. Because by the time I was halfway done into it, she asked me frontally, what is your case about? And that is something that lawyers must understand too, because fact is the fountainhead of law. It's like if you have a human without skeleton, the flesh is going to fall and crumble. So sometimes I even believe that fact is more important than law, because it is law that you apply to facts. Without fact, what you have in the statute book, they are just a combination of alphabets. They cannot get life without facts. So she asked me, "What is your case about?" And I explained it. I explained it, and by the time I was like halfway done into it, she told me, "I'm going to hear you," and she heard us that day. And everybody in court were like, oh, shocked. So you must know the foot to put forward. I was at the Supreme Court one day when a lawyer was speaking, and I think the late Justice Nweze of blessed memory said, every time you open your mouth to speak, I'm compelled to like charge maybe, did he say $100 or something? And that shows you how ridiculous my lord thought the lawyer was. So you must come with your strongest point. So I feel it's always a matter of how you start your approach and whatever it is you are introducing all in the name of adumbration. Thank you so much. I'm sorry for taking your time. I can't hear you. I can't hear you. I can't hear you. Yes. I still can't hear you. Yes. What could it be? Is it from my end? I still can't hear you. No, I can't hear you. Is it from my end? I don't think so. It's not from here. Let me try to connect back. Oh my God. Is it the network?
Can you hear me now? Hello?
I can hear you now. I can hear you now. I can hear you now.
It was actually from my end. So sorry about that. A call came in
Okay,
and
okay,
muted me while you were speaking. So I didn't
okay,
realize
okay,
that. I'm still trying to get the hang of these live sessions. So thank you so
okay.
much for doing justice to the question once again. I'm going to follow it up with another one and say that, okay, can you all hear me now? People are saying they can't hear us. Okay, yes, they can. So the question I want to follow up with is it possible to make a good case or a bad case good with adumbration? That is one. Like you know that adumbration is like that's the final opportunity you have to address the.
Yes.
So is it possible to repair your case during adumbration? Do you think that's possible? And that's one. The second leg is, can you introduce new facts, into your matter in support of your case during adumbration?
Okay, thank you. To the first question, the law is that even a written submission cannot take the place of what of evidence already laid in trial. But I believe that adumbration can actually make a bad case, a bit manageable. And I'm going to cite an example for you. The example is that if you look at the concept of allocutus, there are
Yes.
times the prosecutor would make a very fine case, and you know that, okay, this is what the law says, this is the penalty for this offense. But there are times that a very brilliant allocutor is made, and the person will know that, oh, okay, when you make that submission, the judge will feel like, okay, let me tamper justice with mercy, things like, first time offender and all that. So I believe that it's possible to make a very bad case a bit fair with adumbration. And what you do in cases like that is you amplify the weakness of the adversary's case and pontificate on the strength of your own case. You hold it up like a multi-million dollars picture, painting. You let the court see it. You emphasize that point. Let's say you have 10 points and 9 are bad. You keep speaking about that one point. So I feel that, uh, judges sometimes they are impressionable, and what they see as opposed to the pages of they go home, they read, processes and all that. But for most people, it is what they see, visual. They will recall it that, okay, when that counsel was making submission, he made this particular point. It might
Mhm.
alter the bearing of a case in your favor. So I feel that yes, adumbration can make a case that is not so good, a bit fair. But what I don't know, or what I am not sure of, is that it can actually, substantially alter the outcome of a case. I don't think it can do that, particularly when you have, evidence has been laid and everything is on record. So uh, I don't think it would fundamentally alter the possible outcome based on settled laws. The second
Okay.
question,
The
what
second,
was it?
I agree with you actually. The second leg of the question is: do you think that one can introduce new evidence in support of one's case during adumbration?
Okay, generally, it is not allowed, but I've seen a case where the introduction of a new evidence sort of changed the outcome. It was a matter at the National Industrial Court. I wasn't, I was not in the matter. It was a matter in the National
Okay.
Industrial Court, and at the submission of the counsel, he said something. He said, "We urge your lordship to do justice in this matter, so that the remaining defendants can actually reap the fruits before they go to the world beyond." So the judge had to ask that, what does that mean? And he said, my lord, you know, that within the period that adjournment was made, and now that one of the one of the claimants had died, and I could see the countenance of the judge. Oh, that's unfortunate.
Judge.
Sorry about that and everything. Something he told me that that could actually have a bearing on the case. You know, that's introduction of a fresh evidence, which was not laid at the trial. So I believe that sentiment, though we say sentiment has no place in law, but as long as we are
Mhm.
humans, you know, element of
Mhm.
sentiment would always work. So I feel that depending on the context, the introduction of fresh evidence can actually be allowed, but as a general rule, no. At that stage, it is too late. It is too late.
Okay, thank you very much. I wouldn't even, I think from your example, a fact being brought to the notice of the court,
Yes, yes,
which
yes,
would
yes. I think that's
then
better.
influence how the judge views or perceives the case. I agree with you that judges are emotional beings, and adumbration is quite similar to allocutors, like you have said. Someone is asking what is allocutors. Please, I'm begging you, go to Battle with Ola, type allocutors. There's a video on allocutors on the channel. Watch it. But just to answer your question in brief, allocutors is a plea for leniency after a person has been convicted, but before they have been sentenced by the court. So it's just telling the court to temper justice with mercy, so that when they pronounce the sentence, now that the person has been convicted, they will look at some of the things that whoever is making allocutors says, you know, in order to reduce or reduce the sentence, or decide on what punishment to mete out to the convict. So thank you very much. We are now going to do a demonstration of adumbration. So you tell us the case, bring us up to speed on the fact of the case that you are going to adumbrate upon, and then you do the demo. Then I want to say, before you go on, you know that when we're watching Hollywood movies, law movies,
Yes,
during
yes,
their court session, they have an opening address and then they have a closing address. Would you say the
yes.
closing address is our own adumbration?
Yes, yes.
Because I
It
noticed
could pass.
that during their closing address, it's a lot of emotional, I wouldn't call it manipulation, but it could be manipulation, made attempts made at the jury, just to get them to see reason with whoever is making the address. And in most cases, it affects the outcome of the case. So would you say that's our own adumbration?
And most of the time, you know, the closing address would flow from the adumbration. So they are like Siamese twins. You cannot easily distinguish. But if you look at the content of closing address and adumbration, they are the same. And I've never seen in practice a situation where the judge is going to allow adumbration, then you say closing address again. No, you have to stick to one. In my 10 years, I've never seen it. So I feel that it just has different names, you know. closing address adumbration, because closing address to is more or less you saying that, okay, these are like the central points of my case, and my lord, based on this point, we are urging you to actually find in our favor. So I believe that there is that confluence between them.
Okay, great. So let's go into the demo. Over to
Okay,
you.
so we've discussed that we have two examples we are going to use. So it's important
Mhm.
for me to lay a proper background for each before we delve into the substance. The first is in a criminal matter, a confessional statement uh, was sought to be tendered by the prosecution, and the defendant said, we are objecting because this statement does not comply with the provision of sections 15 and 17 of the Administration of Criminal Justice Act. And they were back and forth. And the judge said, you know what? It's an interesting submission that the two sides have made. Counsel to the defendant, would you please bring this objection formally, file an application formally to challenge the admissibility of this confessional statement on that point? You avail the prosecution the opportunity to reply on the point. Then we can come to court, we take it formally, then a ruling will be delivered on it. So I've assumed the place of the defendant's counsel who
Okay.
raised the objection. So what you want to do now, what you want to adumbrate, I made some sketch that will be a guide for me. What you want to adumbrate on now is, first, we are going to adopt the application, which is a motion.
Okay.
When we adopt it, then we go to adumbration. So let's start from adoption.
Okay,
So,
great.
my lord, our application carries motion number XYZ. It was dated 6th of June and filed on the same day. The said application seeks a loan relief, to wit, that the purported confessional statement of the defendant be deemed inadmissible for non-compliance with the provision of sections 15 and 17 of the Administration of Criminal Justice Act. The application is supported by 3 grounds and a 12-paragraph affidavit deposed to by one Kenneth Ude, the second defendant's father. A composite written address also came with the application. The said address represents both our factual and legal submissions on the loan issue for determination. We adopt the said application in its entirety in urging your lordship to resolve the loan issue in the second defendant's favor, and hold that this is purported confessional statement is inadmissible. If there's a further affidavit that you've done, there are some courts that we ask you to take your main application with the further, so that you don't have to sit the other side will take it, then you go back to it, they will tell you to take it together. So if the attitude of the court is okay, take your main application with the further and better affidavit, you adopt that immediately after the adoption of the main application. So we've done that. We've adopted the processes. Let us go to adumbration. If your lordship is inclined to indulge us, we would most humbly like to adumbrate on just one point that lies at the heart of the issue for determination. My lord, that lone point is the interpretation that should be given to the word may as used in sections 15 and 17 of the Administration of Criminal Justice Act. So we assume that, my lord, Justice Ola already gave me a go ahead.
Yes,
So
that's
we
true. This
start.
is my phone. Yes, go on,
My lord,
counsel.
so we say the kernel of the respondent's response of the respondent application is that the use of the word may in the section under reference connotes, no, the submission of the defendant applicant is that the use of the word may in sections 15 and 17 of the Administration of Criminal Justice Act connotes compulsion. To this, the prosecutor thinks otherwise. My lord, In the very recent case of Issa against State, which we have cited in our address, the Court of Appeal stated that the effect of sections 15 and 17 2, 3 and 4 and 5 of the Administration of Criminal Justice Act on the procedure to be adopted to ensure credible recording or procurement of confessional statements is that it must be recorded in the presence of counsel to the suspect or accused person and by means of video or audio visuals. In Charles versus State, which we have equally cited, while speaking in the same tone as the Court of Appeal, the apex court of the land went further to state that even where the prosecution has ignored the provision of the law as sacrosanct as this, your lordship has the power to so much to raise that point. My lord, incidents of recording confessional statements in the absence of a legal practitioner or electronic recording is no longer legally permissible. On this point, we call in aid the case of FRN versus Akaize. In that case, the Supreme Court, while speaking to the obligatory nature of recording confessional statements by suspects in constraining the word may as used in the provision, held that there are cases, like in the instant case, where the person or authority named in a statute entrusted with a power, it becomes a duty to exercise it and not a discretion. It has been established by a long line of decided cases that the court would interpret the word may as mandatory wherever it is used to impose a duty upon a public functionary to a private individual. In this case, the police is the public functionary. Our client, the defendant, is the private functionary. My lord, in our final analysis, given the objectives of the provisions, to give a permissive coloration to the provision will mean that the legislature gave a kick with one hand and snatch it back with the other hand.
Mhm.
That will reduce the provisions to futility and defeat their purpose.
Mhm.
Courts are to adopt and most humbly urge your lordship to so hold. That is adumbration. You observe that I anchored on the interpretation of me. There
Mhm.
are other submissions in the process, but
Yeah.
the prosecution has anchored its objection, its counter on me, that that provision states me that it is not compulsory. So the document is admissible. That was why, among everything in my address, in my application, I paid special attention to me. And you observe that when I was citing authority, I wasn't going the full length of, for Nigerian weekly law report, the case of X and Y, which we have cited in our written address. So that is
Just
adumbration
to
on
show
that
that we're
point.
already before the courts.
Yes. So it's that me, which is their strong point that I sought to destroy during adumbration, to amplify that no, the point does not make sense or hold much water as the prosecution is trying to make it appear. So when the judge goes back to chamber, he or she is not going to resolve the issue of may, on the face surface based on that adumbration. The judge will remember that, oh, okay, this guy made an issue out of this issue of may and not, or not. So let's dig deeper on it. So that's adumbration on that point.
And you've highlighted Supreme Court decisions, to support your claim. So it's not just you, giving the court your opinion in the matter. You have backed it up with judicial precedents. So the court will be forced to pay
Your voice is
attention
breaking.
to
Your voice is
those.
breaking.
Oh, it's breaking. I'm sorry. Is it better now? Is it better now? Wait, I'm coming. Yes, is it better now?
Yeah, it's better. I can hear you now. Please.
Okay, yes. I'm saying that you have also cited Supreme Court decisions, during adumbration. There are things in your written
Yes.
address, but now that you've highlighted it, when the judge is writing their ruling or judgment in the matter, they will be forced to
Yes.
check those decisions and then check further
Yes.
decisions to see if there's a uniformity in the position of the superior court, in agreeing with you on the interpretation of the word may. So basically, I'm trying to say that from the demonstration you have given us, adumbration is not so much about telling the court your opinion or your leaning, but also backing it up with how the court has decided in times past,
Yes.
and highlighting, those decisions that you're cited in your case just to strengthen your matter. Thank you very much. I think that's a very wonderful example. Even
Yes.
I, being the impromptu judge in this matter, I rule in your favor. So
Thank you. In
let's
fact,
go.
there's a point that eluded me that I wanted to mention. So, for instance, the case of FRN versus Akaize is a
Okay.
2024 decision by the Supreme
Oh,
Court. So, in
that's
your
nice.
adumbration, you may go the extra mile of saying, "My Lord, that FRN versus Akaize is the most recent decision of the apex court on the point." So
Mm-hmm.
that's part of the things you can do during adumbration, that there's nothing on the point that is more recent than that decision. And it's the
Oh,
decision of
that's
the
very
apex court of the land.
interesting. Mm-hmm.
Yes, yes. So that's what you can also do in adumbration.
Thank you very much. So let's do the second one. I think that anyone that
Okay,
wants to learn how to adumbrate, having watched the first one and watching this one that you're going to do, they should be home and dry about what adumbration is all about. Please, I'm reading your
okay.
comments. You can keep them coming. Thank you very much. All these questions, can adumbration? Okay. Please go ahead, our guest.
Maybe if we have the time, maybe we can look at two or three of the questions after the main session. So it's not a problem. Like
Okay.
today has been dedicated to this show,
Thank you very
so
much.
it's
Oh.
fine.
I'm very grateful.
Yeah.
So if you're on
So
this live session and you have questions related to what we're talking about, please them keep keep them coming in the comment section so that at the end of this second demo, our guests can just get to them. Yes. So the second
okay.
demonstration.
So the second scenario is
Okay. Hello. Oh. Okay. Great. You're back.
Thank you.
Yes, it went off for a while. For a bit. It's coming back. I think maybe someone has called him. You know that when someone calls you, bounces you off a live session briefly and returns you. So let's wait for him to come. He's back.
Okay, I'm sorry. That's from my end. I'm sorry. So,
We can't hear
can you hear
you.
me?
Yes. You're
Hello,
mute.
can you hear me now?
Wow, it's
Wow,
very low.
what's happening? Can you hear me now?
Yes, we can hear you, but it's still far away. Can you mute
Okay,
and unmute?
so
Mute and unmute. Let's see.
is it better now?
Keep going. They say they can hear you in the
There's
comments.
no
So, but
improvement.
I think it's fainter than before. But keep going.
Should I try to change the position of the phone? Is it better? Is it any better now?
Yes, yes, it's perfect now. It's perfect.
Okay, okay. So the second case is a civil matter, a divorce matter, and I assume that we represent the petitioner who filed the petition, and essentially the point is that the respondent has repeatedly demonstrated his unwillingness to keep being with her in the same house after a period of 33 years. So the central theme which we want to adumbrate on here is whether in the settlement of matrimonial properties it is only moneyed contribution, as in, okay, my name is on the title document, or this is a receipt showing that I paid for the roofing of this house. The question we want to ask, the adumbration we want to make is whether it is only moneyed contribution that the courts would focus on in the settlement of matrimonial properties, that is, in the sharing of matrimonial properties between parties. So
Okay.
again, we go to our written address. we adopt it before we adumbrate. So let's go. The petitioner's final written address is dated 6th June 2024 and filed on the same date. My lord, the said address captures the summary of the facts laid bare before this court and settled case laws that are on all fours with this case. We rely on the argument in the said written address as the summary of our case on behalf of the petitioner, and we adopt same in urging your lordship to grant the relief sought, particularly in relation to the settlement of matrimonial properties. It has been adopted. Now, let us go to adumbration. I'm going to start with another technique. Your lordship, we had the privilege of looking at the course list, and we understand that this court is a very busy court. It is not in our nature to render an oral rendition of what is already contained in the final written address. However, there's a point that is integral whether or not contribution to matrimonial properties should be measured through the thin lenses of moneyed intervention. We seek your lordship's indulgence to, in just 2 minutes, adumbrate on the point. Justice Ola said we should go ahead. Now let's go. As a prefatory remark, prior to the institution of this petition, the petitioner and the respondent have been married for a period of 33 years. The last child of the marriage is 27. She got married just last month. These facts are before your lordship, and I have emphasized them to demonstrate that a very significant part of the petitioner's life has been spent in her union with the respondent. However, the respondent in his final written address vehemently opposed the relief on sharing of the matrimonial properties. His basis was clear, although unfair, as he argued that the title documents and receipts to all the properties, both movable and immovable, carry his name, and no evidence that the petitioner contributed a dime. To this, we call in aid the case of Ibiabuchi versus Ibiabuchi, cited at page 14, paragraph 6.0 of our final written address. In that case, the Court of Appeal held that two of the most firmly established guidelines in determining a question of settlement of properties is whether or not the property was acquired by the parties during the course of the marriage, and if so, what was the contribution of each party to the cost of acquisition. In the instant case, the first leg has been answered in the positive, as the properties were acquired in the course of the marriage, and that fact was not disputed by any party at any point. On the second leg, as per contribution, the poser is, should we construe contribution solely in a moneyed approach? Our answer is in the negative. We submit that
Your
contribution of a
voice is
party.
lower.
We submit that the contribution of a party does not necessarily have to be in the nature of cash outlay alone for the purchase or development of the property. It can be by way of moral contribution to the businesses of a husband by a wife, or other forms of input during the pendency of the marriage. Our position enjoyed judicial baptism in the case of Ogunubi against Ogunubi, which featured in our final address. In fact, we find Ogunubi's case as having a place of pride in the instant case, given the very didactic and progressive dictum of the Court of Appeal on the point. Be that as it may, it is pertinent to say that the contribution of a party does not necessarily have to be in the nature of a cash outlay for the purchase or development of the property. It can be by way of moral or financial contribution to the business of a husband by a wife, where the property is purchased from the profits of the business. It is, however, essential that the property should have been purchased in the course of the marriage, or where the property was purchased before the marriage, that the payment or completion of payment or development on the property was completed after the course, in the course of the marriage, just like in this case.
Sorry.
Finally,
Someone is saying they can't hear you in the comment section. What do we do?
Can you hear me now?
I can hear you, but it's fainter than before. But I can hear you. But someone is saying they can't hear you. And they've typed like 3 times. Can't hear you, can't hear you, can't hear you.
Can you hear me now? Hello?
It's still like,
Wow, what could be the cause?
what could have happened?
Maybe I should try to disengage from the airport. Hello? Hello?
Yes, I can hear you. Can you make a
Is
sentence?
it
Let's see
better?
if it's better. It's not. It's not.
It is not.
No.
Let me try to connect back.
Okay.
Oh God. Wow. I'm trying to connect back.
Okay, no problem.
Is it better?
Can you make a sentence?
So the point I'm trying to make is it better now?
I'm not certain. Please let me know in the comments. You can continue. I can hear you, actually.
Oh, wow.
Okay.
Okay.
It's perfect.
So finally, my lord, since the respondent has demanded for evidence of her contribution, here they are. 1. 27 years of marriage. 2. She had no choice but to follow as he traveled the world based on his career demands. She could not hold a job because his own job requires him to move at the shortest notice. She's the mother of his 3 kids and she raised them all to adulthood. 4. She held the home front. 5. She has no backup plan. And now that he has forced her hand to fight for divorce, he desires her to start life empty-handed. None of these facts were denied by the respondents. What evidence of contribution could be better than this? We thank your lordship. You did not answer that. It was a poser that would be long-lasting. We have a party who has said, all the title documents, they are in my name. There's no receipt showing that even a TV, she bought it in the house. But you are trying to demonstrate that if you are talking about contribution, 33 years of marriage, there's no contribution. She raised 3 children in the marriage, no contribution. The last child of the marriage even got married. She's 27, no contribution. She could actually not hold a job because your own job requires for you to travel all over the world and she had to follow, and you are talking about contribution. So
That's
you
unpaid
ask
labor.
them.
Mm-hmm.
My lord,
Okay.
what other evidence of contribution do we need? So we leave that at that. So those are 2 examples of adumbration. It could be better too. It could be better too. So
I think
I hope
think
that
that's
they are very clear
fantastic.
in the recordings.
I think that's fantastic because this second example is very important too, because you know that we do not have provisions for matrimonial property in Nigeria. There's no such thing. And the court has held that whoever can prove what they have contributed in a marriage, they will get the value, you know, when the marriage is being determined. As a matter of fact, there's a case that I spoke about when I talked on matrimonial property on the channel. Please watch the video if you haven't seen it, if you are watching this particular session. In the case, it happened in Lagos. In the case, the court had said that the wife had laid claims to the house that a particular building that the husband built, that they built as matrimonial property, and she wanted a share when the marriage was coming to an end. The court had ruled in her favor because she could present, I think she could present receipts of buying cement, and all of that when the property was being constructed. But in a situation where a spouse that is now being divorced did not contemplate the divorce, it might be impossible for them to keep receipts. So I think it's fantastic that this adumbration has appealed to the sense of quantifying the unquantifiable, you know, in a way, so that the judge will look away from the monetary value and look at, if someone has dedicated 33 years of their lives, you cannot now say that they have not contributed. That's unpaid labor, as the International Labor Organization has recognized. It's unpaid labor, and
Yes.
there should be a way to quantify it and then repay whoever has done that. So thank you very much. So if you are
In
viewing the
fact,
channel,
there are
yes, please.
sorry, I said there are decisions. Nigerian jurisprudence. I think quite a progressive, path these days. And I've seen authorities in that line before that. In a marriage, a partner is asking that for you to get something out of this marriage, show the court the receipt of your contribution. And our point is to the court is that, okay, by doing that, he's now trying to, water down the effect of marriage. This is not a business arrangement where you say that you are business partners. Okay, I'm buying a remote, there's a receipt for it. This is marriage. Parties are meant to be lost in it. So if you are talking, and I've actually read another, the funny thing is sometimes when I think stuff up and I make submission, when I check Law Pavilion or something, I see arguments in that line. Because you cannot say that contribution in marriage should be, interpreted under the very thin and narrow purview of moneyed contribution. That is not just. We have men who are high flyers because there's a woman who opted to be a sit-at-home mother.
Exactly.
She's with the children and everything. So is that not contribution? And cases like Ibiabuchi versus Ibiabuchi, I think that there's a progressive thinking in that case that look, it's not, we cannot just look at it from the aspect of moneyed contribution alone. Moral support and all that. It will
Hello. Okay. Are you back?
So that's that.
Are you back? Can you hear me?
Yes,
Hello.
I'm back.
Okay, we
Yes,
lost
I
you
can
for.
hear you. I can hear you.
So I think even on the point that
Yeah.
you're making,
So
I mediated a matter. I think a few
I'm
years
with you.
ago, and it was between this woman was a PhD holder. She was a scholar in general, and then the husband was less read. I think he had an HND or OND or something of the sort. So the marriage had come to an end, and there were claims about, oh, I did this for you, I didn't do that for you, you didn't contribute, you spent all your time studying this and that, and then the wife would be like, oh, you also spent your time being a pastor, doing this and that. You didn't give me, we were even spending my scholarship money and all of that and all of that. And I remember that the husband made a point at some point and said that, when our laptop had crashed at some point when she was writing her dissertation, he had um, he had spoken to a friend who gave her another laptop for free. And that's what she used for her program. I'm just trying to say that, in that sense, he has not bought her the laptop. So he hasn't contributed monetarily, but he has facilitated the laptop. If he was not in the picture, she would not have gotten that laptop at the time. So it's important, and it's really fantastic that our courts are looking away from monetary contribution alone, because it shortchanges a lot of parties. Because no one, I was in a divorce case one time in Benin, and then we put the wife in the dock, and we asked her, the husband had claimed that he was one funding her even when she was abroad. He was even paying her rent for a UK apartment from Nigeria and all of that. Then she was counterclaiming that she was, in fact, the one funding the man in Nigeria. And then we asked her for receipt. And then she made a statement that is somebody that is preparing for war that gathers receipt. So, she didn't have receipts. So I think that it's a fantastic point, because
Yeah.
most people would not have receipt of these things. So it's good that the court is looking away from that. And let's not stray too much away from our point. The point we're trying to make here is that in adumbrating, what counsel has done is averting the mind of the court to quantifying that which cannot be quantified in monetary terms, so that his client is not shortchanged, by the myopic and narrow criteria of money. So I think that you've done justice to the matter. I think all the questions have been answered. So, like I said, let me go back to the beginning to see all the questions. So, if anyone has any questions before we round off, you could leave them. Well, I'm going to go to the beginning and see what people have said. Yes, there's that person that asked for your name and for your law firm. So, let's hear from the horse's mouth and your LinkedIn name. And I think at this point, just tell us how we can reach you, social media, email, the whole works for people that came
Okay,
late and that will watch later.
my name is David Oluwasegun Ogundipe. So on social media, on LinkedIn, I have David Ogundipe. Facebook, I have David Ogundipe. So it's only on Twitter that I try to use money banji, just a pseudonym.
Are you
The
sure?
name of
The magistrate that saw my poster said they know you from Facebook as Omoni Banjio.
no, I have another account on Facebook, Omoni Banji,
Okay.
where I actually try to make posts and comments like a regular citizen. You know, as a lawyer, there are things you cannot say.
Okay.
There's an account where my picture is there. I make comments and post like a lawyer. On the other one, I make
Okay. That's perfectly
comments and
following
post like
from.
a regular Nigerian. So I use Omoni Banji as a pseudonym. It doesn't even have my picture. So but some people know me from that. They understand that the person behind David is still the same person behind Omoni Banji. So the person is
Okay.
actually right. Yeah.
Okay.
So the name
So
of the
on
law firm is
LinkedIn, how would someone find
David
you on
Ogundipe.
LinkedIn?
David
David
Ogundipe.
Ogundipe. So I hope
Yes.
that whoever asked the question knows that. Your law firm,
The name of the law firm is Earnest Attorneys.
Ernest Attorney.
EARNEST. Yes.
Okay.
So
Your email
for now
address,
we are in
possibly.
Abuja.
Okay.
So okay, you can reach me at david.ernestattorneys@gmail.com or mail
Okay.
davidogundipe@gmail.com, either of the two.
Is that the one I have? Let me see.
Yeah.
Okay, the one I have is maildavidogundipe@gmail.com. That
Yes,
also
yes,
gets
that's
to
my
you for most
primary email.
purposes.
Yeah, yeah.
Okay, yes. So someone has asked, can adumbration be done in a written address? I think the person has misconstrued the whole concept of adumbration, if this is the question, because adumbration is highlighting your written address, essentially. In the past, we had oral addresses in Nigerian courts. I learned that is it Chief F.R.A. Williams
Yes,
or which of them, addressed the court for, is it a week or 2 days or 48 hours or a length of time? And the court would adjourn, we come back, continue. He kept on talking and talking and talking and talking. And I recall, I also know of what has been described as the longest address. Okay, it wasn't even given, so it doesn't apply. I wanted to talk about the Gambian political prisoners address that I wasn't allowed to give. It was referred at some point as the longest uh, address or allocutus ever given, but that does not apply in this case. So essentially, when you filed your written address, like our guest has demonstrated, and the court has given you, there's a video, in fact, there are videos on written address, adoption of written address on the channel. So please look for them and watch them. So after the court has given you a day to come and adopt, when you come, you adopt like our guest has done. You will notice that in each case, you would adopt the written address before the court, and then you would now adumbrate. So if you say, can adumbration be done in a written address? No, a written address is filed, adopted before the court, then adumbration follows. Adumbration is to highlight, the key points in the written address, just as our guest has explained. So, you have anything to add to that?
yeah, you've done justice to the issue. So
Okay.
you are very
Then
right.
there's another question. Is it important to adumbrate on all issues or the most relevant? You want to re-answer that because I know you've talked about it.
Yes, you don't have to adumbrate on all issues. You know, there's something different firms, they have different practices, but what we do usually is we use what we call scale of preference. Anytime we are going for adoption, scale of preference. Every case you have, if you look at the issues, you can tell yourself that this is the most important. They cannot be on the same pedestal. They won't be on the same level. And there are times you is it, did they say don't win the war and lose the battle or something? I don't know. You know, you must know the victory you want and go after it. So when you look at your issues, you've argued 4 issues. Have a scale of preference. Okay, on this divorce matter, I'm arguing about settlement of property, I'm arguing about custody, I'm arguing about this and that. Which of them is most important to me? So you can pick 1 or 2 and during adumbration. But when you start picking all the 4 issues and everything, it's no longer adumbrating. Remember that adumbration is a sketch, oral sketch of what you have in your written address. The court will go and look at the most important point. So I think that's the best way for adumbration, except you are a senior advocate whom the court can allow the leverage to speak for as long as they want. Yeah.
Thank you very much. So there's another question. Okay, I think the person is clarifying that first question where they had asked if there can be adumbration. Can you see the questions from your end?
Yes, I can see them.
Can you see the questions from your end?
Is it there's written address and final written address? That's why I asked. Is it the distinction between a written address and final written address?
No, I think that they are saying that's why they asked if can adumbration be done in a written address. That's why they asked, because there's written address and there's final address. And I think that I specifically asked, and that's what you did. I think the first one is for a written address and the last one is for a final address. Yes, the examples that you gave to us. Because, in the first one, you were talking about the use of the word may. I would like to think that that's probably for trial within trial.
Yes. A written address in support of an application.
Okay, that's so that would take a ruling at the end. But the final one that you did is a final address. So you're adumbrating on a final written address in a matter, which will bring about a judgment. So they are different, actually. I hope it is clear. Or do you have anything to say on that? Yeah, I think that's it. So the person that asked the question, our guests are adumbrated on a written address in the first instance on the issue of the word may, and then in the second instance, they are adumbrated on a final written address. Essentially, any written address can take adumbration once the court permits you. You can adumbrate whether it's the final address in the matter or it's a written address in support of or in opposing an application. So I hope that is clear. I think that's all the questions. So whoever watches it, they would leave their questions and I will get to it, much later. So thank you so much for doing this once again. I'm going to put these
Welcome. It's a
details
privilege
in the description box so that people can contact you, as the case, as the need may arise. So we are very grateful. We hope that if we call you again, you will come.
Definitely. It's a promise.
Thank you so much. So we are going to go offline now. We are going to put an end to this live. Thank you to everyone that was able to join us. We appreciate you. And thank you to everyone that will watch much later. We hope that you get, the value that we have gotten from this session. Thank you. So bye from this end. To
Bye.
the end of the live session.
Bye. Thank you.